All right, everybody. So, gentlemen, stay in your seats. Please stay in your seats. Keep your door shut. All we're going to address today is bond. Okay, so you're not really going to have a chance to talk because we're just addressing bond, much like first appearance. Make sure you please listen. Okay, I'm going to give you stuff like no further contact, stay away, etc. And you will need to have no further contact and stay away. So make sure you take that up with your lawyer. Your lawyer typically will mail you a copy of the bond order. Between now and the time you get out of jail, you may miss it. If you happen to miss it, please reach out to your lawyer afterwards and ask for a copy of your bond order because you're not going to get it from the court. So please make sure you reach out to your lawyer and ask for a copy of your bond order. And that way you'll know those conditions and to abide by those conditions. Anybody that's here from bond modifications, those come a little bit later. Okay, we got to take care of all the inmates first, and then we'll hear the bond modifications. So if you need to go do something really quickly, you can, and then you can come back. First one is Ronquell Green. Mr. Melnick. Where's Mr. Melnick? Wait, I think YSL's in today, so he may be running late. Mr. Melnick.
Yes, Judge, and I'll send him an email just to get an update.
Okay. And what about Jeremiah Pernawan? Is Rondon? It's Rondon? No Miss Rondon yet? All right, hold on. We got to get a lawyer here. Oh, Ms. Rockwell, Mr. Samuel already negotiated the modification so that the two co-defendants could move back in together. Oh, there's Mr. Melnick.
Mr. Melnick is on now.
Then may I be excused, Judge?
Yes, ma'am. Have a good evening.
Thank you.
And Mr. Moen says he's going to do a motion to withdraw. So if you just do a substitution of counsel or do an entry so we can put you in there. On Miss Pittman.
Miss or Mr.?
Mr. Pittman, sorry.
Oh, okay. All right.
Yeah,
thank you.
We'll have you down. Okay, thanks. Have a good evening.
Thanks.
All right, let's see. Mr. Melnick.
Yes, Judge. Good afternoon.
All right. Is Kayla Weathers? We got Kayla Weathers in yet?
Hello, Attorney Chris McCormick for Miss Weathers.
I don't think we have ACDC here yet. So let's go back real quick to, I don't see ACDC. All right. What about Ronquell Green? You ready, Mr. Melnick? I know we didn't give you much time.
Yeah, I'm ready, Judge.
All right. As soon as ACDC gets here, we'll get Miss Green. All right. This is position 5, Bostic 23 CP 216272, 98 days without indictment. Right now, there is a $12,000 good bond with $600 apiece on counts 5 and 6 and no bond on the remaining. Possession of cocaine, possession of Schedule 1 or 2 controlled substance, attempt to purchase, transfer a firearm when prohibited by 1611-131. Possession of a firearm or a knife during the commission of or attempt to commit certain felonies, distracted driving, and marijuana less than an ounce. Free.
12 prior arrests, 1 FTA, prior conviction for carrying a concealed weapon, on probation for aggravated assault and robbery in 2010, since 11/29/10, 8 years confinement, 12 years probation. He was convicted in 2010 for burglary and armed robbery, another burglary and armed robbery, and a meth. Nothing further.
All right. Go ahead, Mr. Melnick.
Thank you, Judge. Mr. Green is 25 years of age. He was gainfully employed working for 1-800-Flowers at the time of his arrest. He will be living in Fulton County upon his release. Judge, not much else to really say about this case. It's a traffic stop. He's been in jail for close to 100 days, almost 100 days exactly. He's talking on his phone. He was driving somebody else's car. The gun was not within arm's reach of where he was seated at the time that the traffic stop took place. He, nothing has really happened with the case up to this point. Even though there is a probation hold, I have worked out a tentative agreement on that. So I'm expecting that he'll be released on that before too long. He does have extensive family that all live here in the Fulton County area. His parents own a welding company, M&M Welding, and he also has an employment opportunity there upon his release from custody.
All right. What says the state?
Evening, Your Honor. State requests an $11,000 bond.
Let's see. All right, how about No drugs unless prescribed, no alcohol, no weapons. Sir, that includes not being around weapons also. All right. 1,000 count 1, 1,000 count 2, 4,000, 4,000, and then 600, 600. 1,000, 1,000, 4,000, 4,000, 600, 600. Best of luck to you, sir. You can lead the booth.
Thank you, Judge.
Thank you. Have a good evening.
You too.
All right, let's see. Miss Rondon. All right, Mr. Rondon, are you ready on Mr. Kernawan?
Is that position 17?
Yes, ma'am.
Did you receive my email from earlier?
Oh, well, people that were handling it. Yeah, let me hold on a second because I know you guys just lost. So is this one that's reset? Okay, remove. What I think this
I think this is one that she requests to be removed.
Okay, sorry.
Yes, but Attorney Rondon, are you going to file a motion so that we have something in the record?
Yes, I'll get that filed today.
Okay,
or
thank you.
This evening.
There is a bond. Okay.
Yes, there is.
Okay.
Good evening.
Hey, how you doing? So, all right. Sorry, Miss Rondon. All right. So this one's removed.
Okay.
Let me get back to it. All right. You have another one, Tommy King. Okay. All right. So you do the rest of them. All right. Let's see. Mr. McCormick, how about Kayla Weathers? We'll be right back with you, Miss Rondon. Thank you for stepping in and handling the rest of them since it's just you and Mr. Olaf now.
Of course.
All right. All right. Kayla Weathers. Where I saw ACDC. Okay. 23 CP 215210. Mr. McCormick, 103 days without indictment. Looks like pretrial was on her bond and came off of her bond. She was at level 1. They came off of it, and it's 103 days without indictment. Possession of Schedule 2 controlled substance and drugs not in original container. Pretrial.
What number?
Number 7.
Okay. In regards to Weathers, 8 prior arrests. Big in 2023, 2 convictions for theft by shoplifting, disorderly conduct, 1 simple battery, family violence, sentenced January of this year for 12 months, 1 arrest for probation violation, a couple other misdemeanors, nothing further.
All right, go ahead, Mr. McCormick.
Judge, Miss Weathers, she's 30 years old. She's a mother. It's my understanding she was in a car wreck before her arrest. She is charged with a Schedule 2 controlled substance. Obviously, I haven't gotten any discovery, but my limited conversations with her is she has a prescription for the pill at issue. It just simply wasn't in the original container. So she's been in jail for over 3 months. She needs some medical attention, as I understand it, based on the car wreck she underwent. She's not getting certain prescriptions. Again, she's 30 years old. She lives in Forsyth County, or maybe Cherokee County, Ball Ground, Georgia. But Judge, we're asking for an OR bond at this point. If not that, she was hired by family. I mean, I was hired by family on her behalf. So she's got obviously limited means. She was employed, is my understanding, before her arrest, but obviously now she's not since she's been in jail for so long. But thank you.
All right. So, Bostic, did pretrial come off of it? Do you know why?
Probably for the case that she picked up afterwards. She's been convicted of 2 thefts by shopliftings in Fulton.
All right, that's what I wondered. All right, go ahead, Mr. Malkin.
All right. Did she have a numbered bond that pretrial came off of, or was it a UJR?
Well, it's the new statute, UJR, and it was level 1, but usually they won't take them back.
Yeah. All right, then the state would suggest a $5,000 bond for her.
No drugs unless prescribed, no alcohol, no weapons. It says random drug screens after 30 days, but it's not going through pretrial anymore. So how about $3,000 and then $200? $3,000 and $200. Best of luck to you, ma'am.
All right. Thank you, Judge.
Thank you, Mr. McCormick. Have a good evening.
All right, you too. Bye-bye.
All right, Ashley Awalt. Walt, sorry, I'm probably destroying that. That's Ashley. There you go. All right, it's 23, Bostic, for Ms. Rondon. 23, CP 215156. 139 days without indictment. There is a $11,500 good bond as of January the 5th for possession of controlled substance and possession of drug-related objects. Pre-trial.
Multi-state offender for in Georgia, Texas, and South Carolina. In Georgia, it was misdemeanors. In Texas, couple of arrests for resisting officer, nothing further.
All right. Go ahead, Ms. Rondon.
Your Honor, Ms. Camacho is going to be handling this one for me.
Okay. Go ahead.
Good evening, Your Honor. Yes, I'm appearing on behalf of Attorney Rondon for this case. Before you is Miss Awalt. She's 30 years old. She has been a resident of Georgia for over 16 years. Her family does live here, including her mom and her children, ages 2 and 1. She's completed the 10th grade. She left school early to take care of her mother. And before being incarcerated, she was working as a house cleaner, also at a mechanic shop for 4 years. If released, she has a good address with her mom at 24 Chetro Street in Clayton, Georgia. She's enrolled in the New Beginnings program while incarcerated, and she is eager to get her life back on track. She would consent to an ankle monitor also. Therefore, we're asking for her bond to be reduced to a more affordable amount for her.
All right, go ahead. What says the state?
All right. Is the defense requesting a $5,000 bond?
Yes.
All right.
All right, we can go along with that.
All right, so well, that's 4,900. Okay, how about 5,000 count 1 and UJR through the jail for count 2? No drugs unless prescribed, no alcohol, no weapons. Stay away from 1360 Holcomb Bridge Road in Roswell, Georgia. No further contact with Jonathan Ownby, Ownby. That's your co-defendant. Best of luck to you, ma'am.
Thank you, Your Honor.
Thank you. All right, what about Brianna Clouden? There's Mr. Schittenberg. Okay, so we got, this is position 24, Bostic, 23 CP 216947. 69 days without indictment, no bond as of 3/16/23, and I'm sure Mr. Schittenberg's going to waive sounding pre-trial.
Yes, sir.
Let me pull her up real quick.
Hold on a second, Bostic. You all right, Bostic?
Yes.
All right, go ahead.
Yes,
no prior history, it appears.
Okay. All right, go ahead, Mr. Schittenberg.
Yes, Your Honor. My client's 27 years of age, and she doesn't live with the victim. The victim lives in St. Louis, Missouri. She's not going to intimidate any witnesses. She has no contact, nor live with her ex-boyfriend, who's the father of the supposed victim, Donald Ray Young. Donald Ray Young physically attacked my client on September 27th, 28th. My client made a call into the police. She, and then they took out a warrant for Mr. Young. And then all of a sudden this came about. And all of a sudden she got accused of all these things, and I have recordings, Your Honor, where the victim's apologizing to my client, saying sorry that this happened to her and wants to get moved past all this. But my client doesn't have any history. I think she has maybe some traffic tickets. There's no propensity to commit future crimes. She's not a felon. She's not a flight risk. She's been in Georgia for over 20 years. She's a GSU former student. She has 2 children, a 7-year-old son, a 4-year-old daughter. She lives with her mother. She's staying at her mother's house and lives with her in DeKalb County at 3465 Riverview Chase Way, Ellenwood, Georgia. And it's not even on her driver's license. She's been staying there since she was hit. So she hasn't had any contact with Mr. Young except him calling, trying to get her back in the house. My client,
the dad, right, trying to get her back in the house, not the actual. Okay.
Yeah, because the son lives in Missouri now.
Okay.
The victim. My client's worked at Ross on Camp Creek for the last 2 years. She's a stocking supervisor, so she has stable employment. Hopefully she can keep her job. She's a U.S. citizen, and she's a Cedar High School graduate. And on top of it, while she's been at the jail, she's been a worker at the jail. Your Honor, we're asking for the lowest amount possible for a bond or an OR bond or something of that sort. She's never been in trouble before, and she's not a flight risk or intimidate victim or witnesses, Your Honor.
All right. Mr. Malkin.
Thank you, Your Honor. The state requests no bond, and I believe Your Honor said he's only been in jail 69 days, so she's not statutorily entitled to a bond at this point. And I would just encourage Mr. Schittenberg to reach out to Lauren McCauley and see if he can get a consent bond with her. Work things out.
Do you have an opinion if we do one of those fancy things like we give it a bond that'll go into effect on the 91st day if this case isn't indicted. That's usually an easier way to keep it back. And then we hold on to the bond order. And of course, if he gets in touch with Ms. McCauley and works something out prior to that, we could do that.
I have contacted the DA's office in the past, and they said they're not willing to give a bond whatsoever.
Did you speak with Ms. McCauley or just?
I believe I spoke to a male. I can't.
Well, that's definitely not Ms. McCauley. So
no, I know that. I think I left messages for Ms. McCauley, and she hasn't. I don't believe she's returned my calls, Your Honor.
Okay.
And I've been told they're not giving a bond because they're going to add on more charges. Well, it's been 2.5 months already. So at this point, we're requesting a bond, Your Honor.
See if Ms. McCauley wants to get on, if you don't mind standing by for a second, see if she has one. Because that's what I can. I mean, I'm inclined to grant no bond, but I can do something in the to keep you having to come back if it hasn't been indicted. In the 90th day, I don't know if you're set down for a pre-lab. So if you hold on and see if Ms. McCauley wants to get on, so you could talk to her. But if not, I'm inclined to do that where we set one out for the 91st day. In the event it's not indicted, then that bond goes into effect on that 91st day.
That's fine.
Okay. All right. Let's see. What about Montrell Minchin? Montrell Minchin. Wave your hand if you're Montrell Minchin.
Your Honor, I'm going to go get them as soon as I take the ladies back.
Oh, all right. I got you. So we got all the ladies down, except for we'll hold on that. All right. Let's see. How about David Haynes? All right. Ms. Rondon, this is one you guys are going to do, right?
Yes.
All right. This one is position 10, Bostic, 22 CP 209767. 348 days without indictment, $12,000 good bond as of September the 8th, 2022. Theft by taking and burglary in the first degree. I've already sent the email, Ms. Rondon.
16 prior arrests, couple of felonies, a theft by shoplifting in 2013, meth in 2015, heroin in 2019. So that makes 3, not a couple. 4 arrests for probation violation, 1 misdemeanor, nothing further.
All right. Go ahead, Ms. Rondon.
Mr. Haynes is 47 years old. He has been a resident of Georgia for the past 20 years. He has a couple years of college. He attended Suffolk Community in Long Island. He does have a good address here. It is 1861 McGee Road in Snellville. He owns that house, or he did own it with his wife. Unfortunately, his wife passed away in January of this year. Prior to being incarcerated, he was working at a company that he does own. It's a cell phone repair company called ATL Tech Labs. He had owned that, or he owns that, and had been working there for about 5 years. Due to the loss of his wife, he really cannot make the bond as currently set. His wife really was part of his support system, and he does have matters that he needs to attend to that are related to his passing or her passing. I would ask for Your Honor to lower this bond to a UJR, or in the alternative, for a bond not to exceed $5,000 so that we can seek the assistance of the bail project. Thank you, Your Honor.
All right, Mr. Malkin.
Unfortunately, based on Mr. Haynes' record, the state would ask for a $10,000 bond.
All right, so we got no drugs unless prescribed, no alcohol, no weapons. And I had before it, he was going to not live in Fulton County. So he's still not going to reside in Fulton County, Ms. Rondon?
Yes, Your Honor. His address is in Snellville.
Okay, so stay out of Fulton County unless you're here for court or to see your lawyer. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. No further contact with your co-defendant, Jason Barber. Stay away from 626 DeKalb Avenue Southeast, and that's good because it's in Fulton County and you won't be coming to Fulton County. No further contact with Shelton Whitley, Whitley. Let's see, no drugs. Make sure I got everything. So I got 4,000 and 4,000. $8,000 good bond. Best of luck to you, sir. You can leave the booth.
Judge, really quick, for Ms. Clouden, does she need to be transported back? Because ACDC can't transport male and females, and she just wants to know if she can take her back to her cell.
Let me see. Text Miss McCauley, but let's see if she's going to answer. I don't know if she's still in the office. Hold on, I'll see if she can jump on. All right, so it went to voicemail, but I got a message. She's in the waiting room somewhere. So let me see if she texts back, if she can jump on. So, you know what? Why don't she just, let me see if she'll respond real quick. She can stand by 1 second. All right, what about Derek Reynolds? Derek Reynolds. All right, ready, Mr. Harvey?
Yes,
All right, this is 23 CP 216-254, 98 days without indictment, no bond on aggravated assault and possession of firearm by a convicted felon. Pre-trial.
Prior pointing and aiming and a battery in Mississippi, 10 prior arrests, which is his felonies, a prior old cocaine, delivering drugs, and another prior old cocaine. Those are convictions are from the 90s, nothing.
All right, go ahead, Mr. Harvey.
Judge, Mr. Reynolds is 53 years old. He'll be living with his aunt in Lithonia, Georgia at 2248 Clayton Ridge. He can be living there. It's a single family home. He'd be living there with his aunt. His aunt has equity in that property, which she was willing to put up to secure his presence. They have a business which is called Helping Hands, which helps the elderly and helps them get to places and to feed the elderly. And I think since he's been in 97 days without a bond, he's entitled to a bond, and I believe a good bond in this case would suffice, number one, in the amount of perhaps $5,000. But the second warrant I want to call to the court's attention, EW 0393228, specifically says that the accused did unlawfully possess a firearm after having been convicted on 5/20/2019 in Fulton County Superior Court. That was not a felony conviction. That's 18 SC 159407. He was convicted of misdemeanor OCGA 1611-102. That was an Alford plea. So there is that warrant is insufficient on its face.
Bostic, what do you see? Any felonies other than that one that?
I don't have, he's talking about the case. I'm talking about those are misdemeanors. It was just pointing and aiming on a battery, but let me look it up.
Okay.
Do you want the number again?
Was it the 18 SC 159407?
Yes, correct.
Yes, that's the case I was talking about, the pointing and aiming and the battery.
Yeah.
The felonies were both reduced. The pointing and aiming was reduced from an aggravated assault, and that was the only felony on that case. The other felonies were no pros, the firearm during and the firearm by a convicted felon with no pros.
That's correct.
Okay, so you don't see felony conviction in there?
Not on that case, no, Judge.
Okay.
I believe that we heard that he has prior cocaine convictions.
Yeah, from 23 years ago, and the warrant that he's here on. We're not here for a preliminary hearing. We're here for a bond hearing. We're here on the warrants that he was arrested on. Number one. Number two, it's been 97 days. He's entitled to a bond. The second warrant should be dismissed because it's inappropriate on its face. And therefore, he is entitled to a bond, and he's entitled to a bond since he hasn't been in trouble, even if he had a felony simple possession conviction in the 90s. Only you and I were around the last century there, Brad.
Speak for yourself.
Yeah.
I was barely, but
in a stay away order, of course, Judge. And he's going to be living in Lithonia. You will not be living in Fulton County.
All right, Mr. Malcolm, what's your position on bond?
All right, the state requests a $25,000 bond on the aggravated assault. The victim is opposed to bond on this case, and Mr. Harvey and I had a chance to speak briefly, but not have our complete conversation because the court was about to begin. But I did let him know that the victim is opposed to bond and in fear of her safety. She still lives in the area where this happened, so she's opposed to bond, but of course he is statutorily entitled to a bond. So the state's requesting a $25,000 bond on the aggravated assault. On the possession of firearm by a convicted felon, the state will take Mr. Harvey at his word on the disposition of that case. However, that the reference to that case, the state suggests, would be mere surplusage if he has also been convicted of other felonies. The cocaine case, even though they might be from 23 years ago, he's still convicted of a felony. And it does say that in the warrant that he has been convicted of a felony in the past. So the state would request a $5,000 bond on that charge. So in the alternative, we could change it to possession of a gun during commission of a crime.
No, you can't change it. You can't change it at all. And we're not here for a preliminary hearing. If we were here for a preliminary hearing, it's a different story. But that warrant is insufficient on its face. And $25,000 is excessive under these circumstances, Judge, especially since we agree to a stay away. He will stay away. He'll live with his aunt in Lithonia, and obviously he will not have any further contact with the alleged victim in this case.
Well, and the concern is that he assaulted the victim every way possible, with a firearm, with a knife, and with his fist.
Actually, no, he didn't.
All right, so here we go. All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Tanika, Tenika, Astin, Astin, which I don't see her on the call here. Stay away from 5021 Old National Highway. Stay out of Fulton County unless you're here for court or to see your lawyer. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. You can come back to Fulton County for court and to see your lawyer only. Don't stop and get gas, anything else. 20 on count 1, 5 on count 2. Best of luck to you, ma'am, sir.
Did you understand all of that, Derek?
He's on mute. He needs a thumbs up or a thumbs down.
You got it?
Thumbs up.
All right. Thank you, Judge.
Mr. All right, good to see you.
Thank you, Mr. Harden.
Mr. Malkin, if you could reach out and text with Miss McCauley.
All right, let me see what I can do.
I think she's definitely willing to work something out where it would go in place on the 91st day.
Okay.
I think she's at an appointment, can't jump on, but that way.
Okay.
You mean to go ahead and go to the next one while we're waiting? Can you multitask like that?
I will do my best.
Have a seat. Unless you're getting mad, sir. Keep your seat, okay? Let's see. Brandon Bullock. Brandon Bullock. There you go. Thank you, sir. 23 CB 216770, 184 days without indictment. As of March the 7th, there's a $60,000 good bond on aggravated assault, possession of firearm or knife during the commission of or attempt to commit certain felonies, and unauthorized possession of a weapon by an inmate. Pre-trial.
9 prior arrests, 1 FTA, 3 arrests for probation violation. Open case is passed the statute 11 SC 100-081, theft by receiving stolen property. Another open case 22 CP 214-149, criminal damage to property, tools, loading and prowling, criminal trespass. Nothing further.
All right, go ahead, Ms. Clark.
Good evening, Your Honor. Mr. Bullock is 36 years old, and he has been in custody on these charges for more than, I think you said 100-something days. So that
184.
184. The court did set a $60,000 bond that he's unable to make. He was born and raised in Atlanta, Georgia. He has extensive ties to the metro Atlanta area. His family lives here, his mother, along with his siblings. He did complete the 11th grade at South Cobb High School. However, he didn't complete the 12th grade. He resides with his girlfriend, Miss Ann Smith. She's indicated to me, and they've resided together for more than 5 years. She indicated to me as an officer of the court that he could, in fact, come stay with her again. That would be at 2500 Center Street, Northwest in Atlanta, Georgia. And of course, he's indigent, so a $60,000 bond is not something he can make, Your Honor.
All right, Mr. Malcolm.
We would request a $50,000 bond, Your Honor.
All right, let's see. So we got no drugs unless prescribed, no alcohol, no weapons, no further contact with Gregory Walton, W-A-L-T-O-N. Let's see. You got to have ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, or employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working to Ms. Clark and to the ankle monitoring company. No further contact with your co-defendants. Eric Oliver Sr., Troy Sean, T-R-O-Y-S-H-O-N Porter. And then it's H-I-F-O-N, last name Smith. Cameron Walker. Jaquan Ellis. Miguel Castillo, M-I-G-U-E-L, last name C-A-S-T-I-L-L-O. So 20, 10, and 10. Best of luck to you, sir. 20, 10, and 10. You can leave the booth. Let's see. What about Vanlin Preston? Vanlin Preston. Wave your hand if you're Vanlin Preston. Nope. Yep, you're okay. Stay awake, gentlemen. Vanlin Preston. Position 3, Bostic. 23, CP 216632. 326 days without indictment. Not necessarily this case. Riot, possession of dangerous weapon or drugs by an inmate, simple assault. Pre-trial. 7 North, booth 1. 7 North, booth 1. 7 North, booth 1. Turn around. Turn around. Turn around, face the camera, pay attention. No sleeping. No, there you go. Go ahead, Boston.
6 prior arrests, prior firearm during Schedule 4, cocaine and meth, 1 arrest for probation violation. Open case in Clayton for burglary. Nothing further.
Go ahead, Ms. Clark.
Your Honor, it appears that he doesn't have any felony convictions, although they're indicating there is arrest. And again, he has those cases that he'll be fighting. He's 31 years old. He's a resident of Fulton County, Georgia. He's been in Georgia most of his life. He is indigent. This case has been pending, I believe, the one that we're talking about today, since February 7th. So more than 90 days has expired. Given that he is indigent and has been in custody for close to a year, we'd ask for the lowest bond possible. And given that he doesn't have any felony conviction, we're asking for the lowest possible bond.
Is he a bond on the other cases, Ms. Clark?
Judge, I'm not familiar with all the other cases, so I'm not sure about that.
All right. Go ahead, Mr. Malcolm.
And what is his bond now? I apologize.
No bond.
No.
All right. And okay. Well, we'll leave it up to the court for reasonable bond. Thank you.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Quayshawn Green Sr. Q-W-A-Y-S-H-A-W-N Green Sr. have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, or employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. No further contact with your co-defendants. Chase Spencer, Frank Hubert, Julian Shipman, Jaquan Fields, Jaquan Fields, Fields, Jermaine Carter. So we'll do 20,000, 5,000, and 5,000. Best of luck to you, sir.
Thank you, Ryan.
Thank you. Mr. Malcolm, did you hear from Ms. McCauley so that we, yeah?
I did. Yes, I did, Your Honor.
All right. So we're back to Mr. Shinberg. Go ahead, Mr. Shinberg. Well, you want to go ahead on your bond argument, or you already did, unless Mr. Malcolm needs to hear it again.
I already did, Your Honor.
All right. Yeah.
No, I don't need to hear it again. We'd ask for no bond now and $25,000 bond on the 91st day.
All right. So, Ms. Parham, we'll just hold on to this and calendar it for that 91st day. There'll be no drugs unless prescribed, no alcohol, no weapons, no further contact with SEHEAVN Young. Stay away from 3000 Continental Colony Parkway in Atlanta. No further contact with Donald Young. And if anything changes, obviously you can get in touch with Ms. McCauley and y'all can change that. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Also, no further contact with anyone under the age of 16, but I believe she has children, right, Mr. Shinberg?
Yes, she does, Your Honor.
All right, that'll have to be with the exception of your minor children, ma'am. So on that ankle monitor, you can also leave for necessities for the children. But if you leave, ma'am, you need to let the ankle monitor company know where you're going. It has to be for those minor children. And Mr. Shinberg, if you don't, they will violate that and you'll end up back in jail, okay? Stay out of Fulton County unless you're for court or to see your lawyer. And no other reason for you to come to Fulton County, court and to see your lawyer. So you stay down in Ellenwood or any other county you need to go to. Right now, it's going to be no bond until that 91st day. Then I think Mr. Buck said $25,000 good bond. Best of luck to you, ma'am.
So, Judge, quick question. I'm sorry.
So we'll count out for the 91st day. We'll hold the bond order. If it's indicted, the bond will just shred the bond order. If it's not, then we'll e-file it.
Okay.
So it's 69 days. We can count it when we're finished up to the 91st day.
So she doesn't go back on the calendar though on the 91st day?
No, 91st day. Okay. No, we'll just, if it hasn't been indicted, we'll e-file it.
So do you want me to send you something that says bond denied for today? The order denying bond?
Ms. Robinson, how did we decide we were going to do that?
I thought we were just holding on to the bond order to the 91st day and not even doing anything because it's already a bond in place for the no bond.
Yeah,
okay,
so
that's
already
fine.
one. So yeah, and we'll just calendar it so it'll like trigger so that we can file it on that 91st day.
Okay.
So Mr. Shinberg, if it's indicted, that one won't go into effect. It'll just go back to still stay at no bond.
And Judge, you said 25,000 on the 91st day, right?
Right, 25,000. Okay. All right, thank you.
Thank you, Your Honor.
All right, thank you. Have a good evening.
Excuse, Your Honor.
Yes, sir.
You too. Thank you.
All right.
Your
Yes.
Your Honor, may I be excused as well?
Yes, ma'am. Yes, ma'am. I know that was your. All right, let's see. We'll go to the next one here. All right, Clifton Garrison. Clifton Garrison.
Good afternoon, Judge. Judy Kim for Mr. Garrison.
He's in ACDC, Your Honor. She's going to get the mail.
All right, let's see. Emmanuel Bush. Oh, on here he wasn't in ACDC. Emmanuel Bush. All right. We'll come back to you, Mr. Kim, as soon as we can get them back. All right, we got position 6, Bostic. 23 CP 216230, 99 days without indictment, no bond on this case as of February the 14th. Armed robbery, ag assault, possession of a firearm or knife during the commission of or attempt to commit certain felonies. Free trial.
2 arrests in Georgia, arrests in Pennsylvania, DUI here, and a fleeing and eluding. Nothing further.
All right. Go ahead, Mr. Sabak.
Your Honor, good afternoon. Cedar Sabak on behalf of Emmanuel Bush. Mr. Bush is 25 years old. He's been in custody since February 13th, 2023, 99 days, like Your Honor indicated. He graduated from Booker T. Washington High School in 2016, did 1 year of college at Savannah State, began working in 2017 as in a temp agency, and then in 2021, worked as an Amazon delivery driver, and then beginning of 2022 until the current time, he's been working for Waste Management as part of the pickup team. His jurisdiction involves Norcross, Suwannee, and Alpharetta area. So we're bordering Gwinnett County and Fulton County. So Mr. Bush, to banish Mr. Bush from Fulton County, Your Honor, would be an impediment to his work. His job, according to Mr. Bush, is still available upon his release. I've spoken with his mother. I'm in constant contact with her. I'll be calling her after this hearing, Mr. Bush. He will live with his mother at 2415 Charleston Terrace. That's in Decatur, Georgia, 30034. Mr. Bush has always maintained employment, Your Honor. We totally deny, reject these allegations against Mr. Bush. He has no history of violence, sticking guns in people's faces, firearms, theft, or robbery. He's always maintained steady employment. Like I said, his mother lives in Decatur. He lives with his mother and will continue to reside with her once he's released, Your Honor. We did ask for a $12,500 bond, $5,000 for the armed robbery, $5,000 for the aggravated assault, and $2,500 for the possession of a firearm during commission of a crime. Thank you.
Can you remind me what kind of work he does that he'll need to come to Fulton County?
Yes, so he's works on the pickup truck. He picks up trash. So he's
for the city or whatever.
He works for Waste Management, and their jurisdiction is that Fulton County, Gwinnett County, Suwannee, Johns Creek, Alpharetta, Norcross line.
Okay. All right. Go ahead, Mr. Malkin.
All right. The state requests a $40,000 bond on the armed robbery, 20 on the ag assault, and 10 on the gun charge. Total of 70.
No drugs unless prescribed, no alcohol, no weapons. No further contact with Tavares, Tavares, Cox, COX. Stay away from 483 Lucky Street. He's going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and that includes employment, sir, for the sanitation job you have. 5 North, booth 4. No. Are you trying to listen? They keep can you not hear good? Go over to booth 1. Go to booth 1. Switch, booth 1. Booth 1. I guess we need to note that Ms. Robinson that 5 North booth 4 isn't.
Yeah, I'll let IT is on. I'll let them know that there's a problem with 5 North booth 4.
All right. Did you hear any of that, sir?
Note taken.
Did you hear any of that? Okay. No drugs unless prescribed, no alcohol, no weapons, no further contact with Tavares, Tavares, Cox. Stay away from 483 Lucky Street. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment supply. Name of your employer, proof of employment, schedule, and the exact location you'll be working. You work for sanitation, so you just need to explain that you work for sanitation for the city or the county. And stay out of Fulton County unless you're for court, lawyer, or your employment. So if you don't pick up garbage or work for sanitation on the weekends, you don't come to Fulton County. So we got 35,000, 20,000, and 10,000. 35, 20, and 10. Best of luck to you, sir. You can leave the booth.
Mr. Bush, I'll be speaking with your mother after the hearing. Thank you, Your Honor.
Thank you. All right, Jimmy Denson. If that's it, you can go ahead and leave. Thank you. Have a good evening. Good to see you. All right, Jimmy Denson. We got it's position 15, Ms. Rondon and Bostic, 22 CP 208471, 397 days without indictment. Let's see, aggravated assault, possession of a firearm or knife during the commission of or attempt to commit certain felonies. There's a $60,000 good bond as of July 25th, 2022. And I've already put this name in my email. Pre-trial.
Extensive criminal history, at least 73 arrests, at least 10 misdemeanors, felonies. Theft by receiving terroristic threats, currently on probation for 4 during the first sentence, March of last year, FTAs, at least 6 probation violations, nothing further.
All right. Go ahead, Ms. Rondon.
Mr. Denson is 44 years old. He has lived in the Atlanta area since 2012. He has made it to the 11th grade. Unfortunately, his family that did live here in the area passed away in January from COVID-19. He does have a cousin, though, that lives in Georgia that owns his own business. It's a enterprise business. His name is Mr. Reed, and he would be able to allow Mr. Denson to come work for him. Let's see.
I think previously
due to the 397 days that Mr. Denson has been in custody, he has lost his housing. And so my office will be working with him to try to figure out transitional housing or something else for him to go to once he is released. His current bond is set at $60,000. I would be asking for the court to reduce that to $15,000 on the aggravated assault and $5,000 on the possession of a firearm.
All right, and I've had previously to stay out of Fulton County, so obviously with the housing, you would need him to be able to be in Fulton if that's
yes, Your Honor.
All right, go ahead, Mr. Malkin.
All right. In light of Mr. Denson's criminal history, the state would request a $55,000 bond.
Okay. No drugs unless prescribed, no alcohol, no weapons. Stay away from 1073 Piedmont Avenue in Atlanta. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical appearances, employment, any other program that Ms. Rondon gets you into. That'll be paid for by the county. You must provide an address to jail staff upon release. So we'll do 40,000 and 5,000. Best of luck to you, sir. Oh, and no further contact with Rasim, I think it is, R-Y-C-E-A-M, Scott, S-C-O-T-T. Best of luck to you, sir. You can leave the booth. Byron Gearing. All right, Mr. Gearing, this position 16, Bostic 22, CP 209-530. 355 days without indictment, possession of Schedule 1 controlled substance, possession of marijuana with intent to distribute, possession of MDMA, trafficking, and cocaine. Let's see. There is a, hold on, I got to do the math here. $350,000 good bond as of June the 3rd, 2022, because there were 2 counts that were actually dismissed. Pre-trial.
17 prior arrests, fleeing and eluding MDMA and obstruction in 2015. 3 misdemeanors, 3 arrests for probation violation. Another firearm buy, firearm doing, purchase, manufacture, and sale of marijuana. Open case 22 SC 18879 for trafficking, assigned to Judge Adams in judicial holds, arrest in Texas. Nothing further.
All right, Ms. Rondon, according to this, allegedly 1,421 grams of marijuana, 7 grams of MDMA, and 109 grams of crack cocaine, allegedly. Go ahead, Ms. Rondon.
Yes, Mr. Gearing is 44 years old. He is born and raised here in Atlanta, and he does have a good address. It is 365 Dartmouth Place, Southwest, here in Atlanta. It is his grandmother's address. He also has 2 children, ages 2 and 5, and he is the primary supporter of both his kids, his aunt, who is diagnosed with Alzheimer's, and his grandmother. Prior to being arrested, he was working with event staffing, and it's my understanding he would be able to return to that employment. He also was doing barber work on the side or part-time. Mr. Gearing has been in custody for 355 days, which is just 10 days short of a full year. His bond is currently set is $350,000, which is tantamount to no bond. I mean, no one can afford that kind of bond amount. I would ask for his bond to be reduced significantly. I do understand the alleged amount of each substance, but I do think that there are appropriate conditions to set for Mr. Gearing to ensure his participation in this court process and his presence at his future court dates. I would ask for his bond to be reduced not to exceed $100,000.
All right, Mr. Malkin.
Thank you, Your Honor. Unfortunately, there were appropriate conditions in place for when this crime was committed. He's got an open trafficking. The state would request a $300,000 bond. Thank you.
All right. No drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. No further contact with co-defendant, Timothy Farris, F-A-R-R-I-S, a.k.a. James Duvall. Stay away from 2950 MLK Junior Drive Southwest, Building 5, Apartment G as in George in Atlanta, Georgia. So it was 1,421 grams. So that was, okay. So we'll do 75,000, 75,000, 50,000, and 50,000. Best of luck to you, sir. You can leave the booth. And I have placed that in my email. I think I already told you that though, Ms. Rondon, but hopefully it moves it along. Maybe. Sometimes it helps.
I think it does. Thank you, Your Honor.
All right. Brandy House. All right, Mr. House. It's 23 CP 216391, 94 days without indictment. There's a $22,000 good bond as of February the 20th, 2023 for robbery by intimidation and simple battery. Trial.
Multi-state, 1 arrest in Alabama. Probation 22 SC 181-773, terroristic threats, PI criminal trespass, sentence in 2022, 1 year confinement, 2 years probation, 5 misdemeanors on FTA, parole violation, other felonies, cocaine with intent, false imprisonment, obstruction and battery in 2012, Schedule 1 in 2019, nothing further.
All right. Go ahead, Ms. Rondon.
Mr. Howes is 38 years old. He is a lifelong resident of Atlanta, and he does have his entire family here, including his mother, sister, grandmother. He does have a good address with his grandmother, and I will be updating the clerk's office with that address. It is 4518 Clement Drive here in Atlanta. That is his grandmother's address. He also has his 3 children here. They're aged 13 through 21. Mr. Howes does have his GED, and he is forklift certified. Prior to being arrested, he was working at a medical warehouse in McDonough, driving a forklift, and it's my understanding that he would be able to return to that employment once released. I would point out that in this case, he was actually shot 6 times, and it is hard to recover from injuries such as that while incarcerated. And so I do believe that he would be better suited outside of Rice Street. And Mr. Howes also has some MH issues that will go along with treatment on the outside. His bond is currently set, Your Honor did mention, it is $22,000, and that is just something Mr. Howes cannot afford. He has been in for 94 days and the case is not indicted. I would ask for Your Honor to reduce bond to not exceed $5,000. We'll have to go through the bail project to ask for bail assistance for Mr. Howes, as he currently just does not have the funds to make any sort of bond over $5,000.
All right. Go ahead, Mr. Balkin.
Thank you, Your Honor. We've spoken with the victim in this case, and she is against bond. And I thought she was going to be on Zoom. I don't see her, but at any rate, she did not want to address the court, but she was going to observe. And she said she's against bond. She is very much in fear for her safety. And based on what the victim has stated, her being in fear of her safety and intimidation and his record, the state is requesting that his bond not be lowered. Thank you.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Jasmine Leary, Leary, or Reginald Turman, Turman. Stay away from 2471 Old National Parkway. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. You have to supply that to the ankle monitoring company and to your lawyer. I added a few things, so it'll be $18,000 and $2,000. Best of luck to you, sir. All right, so since we're waiting on ACDC, we can go ahead with these bond modifications. Let's see, do we have we got Ms. Edwards. Do we have Mr. Is it Anasiki?
Asanichi, Judge.
Asanichi. You know my accent, Miss Edwards. I can't believe I can pronounce Edwards correct without messing it up with this accent. Let's see. All right. We got 22 CP 211159. Got false imprisonment, cruelty of the third, and you're going for a bond modification. What you trying to modify?
Well, Your Honor, we were here before. I don't know if you remember this case, but the couples is going through a divorce, and you ordered them to get a guardian ad litem regarding the minor child. The case is before Judge Farmer for the divorce, and we've had a temporary hearing since we were last in front of you. I believe we were in front of you in January of this year. So the parties consented to the child having visitation, and so dad still speaks to mom, I think only during text or through our family wizard, but they have already agreed to consent or, for the dad to have the child. So he does have parenting time with her on a weekly or bi-weekly basis. And so we had spoken to Ms. Weaver, and she was in agreement to have the bond modified so that dad could see the child. So that is what we're asking today, that this bond be modified to mirror what the parties have already agreed to in the divorce.
Is this supervised visits? What did they agree to?
It is not supervised visits, Judge. There's a guardian ad litem in the case. Brandy Alexander is the guardian in the case, and like I said, it's in front of Judge Farmer. So dad has the child on Wednesdays, the second and fourth from Wednesday to returning the child to school on Thursday, and then that's for the second and fourth, and then the first and third, he has the child Thursday, picking her up from school and return to school on Monday.
Okay. Mr. Malkin?
Let's see. I'm not really in a position to discuss consenting to this request because I have not heard about this request before. Has written documentation been provided by all the parties involved, the guardian, etc.?
Yes, actually, the guardian was present at the hearing, as was her counsel. She's represented in the divorce as well. She was present, and it was something that she agreed to as well. Judge Former wanted us to modify this. Go ahead,
is there
Judge,
an order
I'm sorry.
yet, Ms. Edwards?
Yes, Your Honor, it was ordered on March 24th.
All right, I guess that's what he's wanting to see as he ordered. Let me see. Do you have that? You got that divorce case number?
I do. It's 2022 CV 365374.
Mr. Malcolm, can you pull that up? I mean,
let me try to pull that up.
Brad, I could email it to you probably as well.
Okay, all right. Okay. All right, that's 22 CV 365374.
Yes, sir.
All right, let me try that again.
oh, you got to put 2022. You have to put the whole thing, not just 20.
Oh, okay. Okay, that's what was okay. Let's see.
I never understood that. I don't know why it's not just 2022, but
2022 022 still not coming up.
Okay, your email is brad.malkin.
Yes. Sorry about that.
No worries, no worries. And it's fultoncountyga.gov.
Yes.
Okay, it popped up. Judge, do you want me to send it to you as well?
I got it pulled up. I said, where's up? I'll pull it up.
Okay.
Yeah, it says this is applies only to the child.
But that's all we're asking for today. We don't want contact with her. We just want to modify because the current bond said no contact with her. And so we have set this up so that he picks her up and returns her directly to school. And they have, I believe they have our family wizard. They do have our family wizard, and which is how they communicate if it is regarding the child. And so we would not be asking for contact with her. We would be asking for contact just with the child.
Okay.
Correct.
Nope.
Sure, it'll be here in a minute.
Oh, I might be able to. You see that, Mr. Malcolm?
Yes.
There you go.
We'll probably get them both at the same time.
Well, let me move over my little screen share thing. Can you read that?
Yes.
If you tell me, I'll click to page 2 whenever you're ready.
Okay. Okay.
Your Honor, if you recall, last time that we were in court, you said that you were going to reserve the issue of parenting time for the judge that's handling the divorce, and you ordered us to get a guardian ad litem. You actually ordered the guardian ad litem before we had a guardian ad litem in the criminal case, because the TPO order that they started with said that the parenting time would be reserved for the judge that was handling the divorce, which is why you said, I'm going to follow what the previous order said, and I'll leave it to the divorce
And that sounds
judge.
like something I would say, doesn't it, Miss?
which is how we got to, well, let's get a guardian just to make
Right.
sure. And mom was represented, guardian
You
was
good?
there, and
You
everybody
don't see
consented.
You don't see the rest, Mr. Malcolm, or you?
It's also come through on the email, so I've got it on my other screen. So yeah, and so what is council requesting other than just an order that's consistent?
I think just
That
an
is
order
it.
consistent with that family.
Just an order consistent, yeah. No contact with her still. They don't see each other to exchange the child, and they communicate through our family wizard only about the child if
Okay.
needed. So.
Yeah, that seems appropriate.
Okay. All right. So you want to you can send that to me, Miss Edwards, and I think you have my email address. You can send it to me, the modification, and we'll send it back to you as soon as I sign it.
All right. Thank you,
All
Judge.
right. All righty. Thank you.
And just one question for Ms. Edwards. The order was signed by Judge Farmer, right? The one that you sent me is not signed?
No. Oh, it was. I have it on
It
here.
is.
Okay. All right.
I don't know which copy I sent you, but I have the signed copy. If I sent you a draft, I thought I sent you the copy,
appreciate
but I can't.
Yeah, the signed copies on Odyssey. The one I was sharing, I just didn't get the last screen.
Thank you.
All right, let's see. All right, let's see. Well, we got the folks back at ACDC, so let's get these going real quick, and we'll get back to this. So we got Montreal mentioned.
Your Honor, are we excused?
Yes, ma'am. Thank you.
Thank you. Bye-bye.
All right, Montreal. So we got 23, it's 18, Bostic, 23 CP 216295, 97 days without indictment. No bond as of February the 16th, cruelty to children, causing excessive physical or mental pain in the second degree. Free trial.
Which number?
18.
18. Mention 8 prior arrests, misdemeanor, 2017 meth, 2 arrests for probation violation. South Carolina, there's a hold in Dunwood. In South Carolina, there's 5 misdemeanors. There's a sale of a stolen vehicle in 2017. Receipt of stolen goods in 2010, and 28 grams or less of controlled substance. And nothing further.
All right. Go ahead, Ms. Rondon. Oh, I'm sorry. Is it going to be you? Yeah.
Yes, it is. Mr. Mention is 28 years old. He has attended some college. He does have 6 children. And prior to being arrested, he was working as a bartender at Bermuda. It's my understanding that he would be able to return to that employment. He has been in custody for 97 days, and he's currently in no bond status. So at this point, he is entitled to a bond. I didn't hear from pretrial any felony convictions. I would be asking for bond to be set not to exceed $20,000.
All right. Go ahead.
Thank you. I think I may have heard a reference to a meth conviction from pretrial.
Meth and stolen goods.
Pardon me?
Meth and receipt of stolen goods.
There you go. Thank you. All right. The state requests a $50,000 bond.
All right. No drugs unless prescribed. No, let's see. All No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. No further contact with SANYA mentioned. Stay away from 396 Piedmont Avenue Northeast. Are there any other children under 17? Ms. Rondon, that you know about?
Yes, Your Honor, to my knowledge, yes.
Oh, will he be around that child or those children?
Mr. Minchin, thumbs up if you'll be around those children.
Let's see, what's your position on that, Mr. Malkin? I don't know if you read that.
He should not be around those children.
And your position, Ms. Rondon, I mean, I read the allegations. Although there's the presumption of innocence, I'm just.
Yes, I would say that this is an alleged incident, and I believe that he should be able to have contact with his children. I believe there is a DFACS plan in place. And so I would ask, that visitation be allowed. And if Your Honor deems it appropriate, then to just follow whatever DFACS plan is in place.
All right, no further contact with anyone under the age of 17 unless this is going through a DFACS case, and then it would only be any kind of, I guess, supervised visits, and no further contact with your co-defendant. Hold on, that's pulling up right now. Let's see, hold on. Of course,
my
it's
co-defendant is the mother of my kids.
Stop talking, sir, please. I know, and you're going to have no further contact with your co-defendant. Unless it's going through DFACS. Hold on 1 second, Ms. Rondon. It's kind of spinning unless you happen to know the name before. Oh, wait.
Okay,
it's SAR.
I was going to start spelling
accent QUANE, last name RIDGLEY. No further contact with that co-defendant. So it'll be a $45,000 good bond. Best of luck to you, sir. All right, Deshaun Boyd. You can step away, sir. Put up Deshaun Boyd. All right, this is position 12. Bostic. Was that it for you, Ms. Rondon?
No, Your Honor, I've got one more.
Oh, the motions, okay. 23 CP 216203, Deshaun Gregory Boyd, 101 days without indictment, no bond as of February the 13th, theft by conversion, manufacture, distribution, sale, false identification, document, or second or subsequent.
Multi-state, Rhode Island, New Jersey, Connecticut DEA, probation violation, misdemeanors, 214 in Georgia, 2020 FTA, open case, financial transaction card fraud. Here in another county, a financial transaction card fraud and theft by deception, financial transaction card theft, and theft by taking in card. Nothing further.
All right. Go ahead, Mr. Drake.
Thank you. We actually had a preliminary hearing on this before Judge Drake, no relation.
And no bond was set, which is surprising because it should have been, but.
Well, a bond was set, Judge. That's the thing. It was a judgment. It was a bond of $5,000 on each count with a hold until May 11th. But that order was never entered after May 11th. So now we're on the 101st day with no order, even though the judge ordered a bond.
What you want me to do?
Ask the court to grant a bond in the amount of $10,000. Stay away from the U-Haul place where that involved this crime. And
Mr. Malkin, go ahead.
Well, they was going to request a larger bond, given that he's got 2 open cases in 2 counties and everything else we've heard. But if a bond order's already been signed, do we know where that might be, Mr. Drake?
No idea. It was kind of like the one I said before, right, Mr. Drake? It was going to be, you have to kind of like calendar it so that it kicks in that day so that you kind of pay attention at all. So I guess it wasn't.
Could it be on the desk of Judge Drake's litigation manager? Or Judge
No idea.
So,
no idea.
Judge, this is on defendant, which one? I'm sorry.
Boyd. It's not one that I said hold. I've only done that to 2. And then one was already put in place. It was going to be put in place this weekend because it's Memorial Day. And then the next one on the 90th day.
Well, I'll take counsel's word for it, Your Honor, and no reason to doubt what he's saying. You know, if it's already a done deal.
Where's he going to live, Mr. Drake?
Judge, at the time, we will probably need to check with Mr. Boyd, Judge, but I thought he'd be living at 370 Northside Drive, Northwest Apartment 2248.
Is that where you're going to live, sir?
Yes, ma'am.
All right. All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from Horizon Rental Car, 1931 Roosevelt Highway, 1931 Roosevelt Highway. But with your history, I'm going to do an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. So you can leave for those reasons, sir. That ankle monitor will be paid for by the Orca Project. You have to supply the place of your employment, name of the employer, schedule, and the exact location you're going to be working. You have to supply that to Mr. Drake and to the ankle monitoring company. So that's $5,000 on each count. Best of luck to you, sir.
Thank you, Judge. Judge, that's
all
all
right.
Thank you.
All right, thank you. Clifton Wade, yes, sir. Clifton Wade, Garrison, Mr. Garrison. All right, Ms. Kim, this is number 8, Bostic, 23 CP 216191, 100 days without indictment, no bond as of February the 13th. Aggravated assault, criminal trespass. Rah!
2 prior arrests. Last arrest was in 04, no disposition.
All right, go ahead, Ms. Kim.
My client is 56 years old. He's married. He has a son. He's a superintendent for some construction company, and he supervises subcontractors. He's been doing this for 30 years. He still has his job intact. My understanding for this case, it was after hours. The alleged victim was working on a site to change the locks to the doors. So it was a tap instead of an insert. His truck was in the way, and my client asked for him to move the truck. He refused, and then he brought 3 of his friends down. Somehow my client, he had a gun on him. He didn't point it. He didn't brandish it or anything like that. The victim grabbed the gun, and then my client asked him to please give it back. He did, but the victim pointed the gun at himself. My client got his gun back and then holstered it and put it away. But they don't know each other. The victim, my understanding, lives in North Carolina. He was terminated from his job because of this incident. But my client still has his job. He's been doing it 30 years. He would ask if you would consider $5,000 in the aggravated assault and a UJR in the criminal trespass.
All right. All right. Go ahead, Mr. Malkin.
Thank you. Good evening, Ms. Kim. The state requests a $20,000 bond on the aggravated assault and $1,000 on the criminal trespass. Thank you.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no further contact with Forrester, SHERMER. Ms. Kim, is he going to live in Fulton County? Is he going back to Arkansas?
Going back to Arkansas, and the victim lives in North Carolina, so they don't even know each other.
All right, stay away from 5465 Windward Parkway, the Sonesta Suites. And you're going to have an ankle monitor paid for by the county, 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, exact location you're going to be working. 20,000 and 1,000. 20,000 count 1, 1,000 count 2. Best of luck to you, sir. Thank you, ACDC.
Judge, if he's working location to location, does he have, because he goes out of state a lot?
All they got to do is supply it to the ankle monitoring company and let them know.
Okay, thank you, Judge.
And you let them know too.
Let me ask you this, Judge. I would ask, because I had a bond hearing the other day, and I guess they have some new technology for something that looks like an iWatch.
Right.
So I don't know if you could do something like that to do the nature of his job in construction.
Don't remember your client. Can he pay for it?
No, Judge. We would ask if the county could pay for it.
Well,
we are in a recession.
I forget. Miss Kim. Yeah. So, what's this? Anybody know the status of that? What it is with the status of that one?
No, I don't know.
As far as the Teletrex monitoring,
right?
I thought that they had to pay for it if they wanted to do the Teletrex. The only one that they were doing with the ankle monitor. You want me to have Phoenix or one of them jump on?
Yeah. Well, there's Miss Lewis is on. Miss Lewis, do you know the status of that still?
Hey, Judge, I think we're still waiting to get some final feedback, but I can check in the morning with Phoenix. And I know we were also working with pretrial supervision just to get additional information on, I guess, the final push for Teletrex.
Okay. So I guess, Miss Kim, if he were to, she'll try to find out if you want to reach out to Miss Lewis and find out, because if it is and he has one, then he can get them switched out. I think there was something like with the contract, kind of, all difficult stuff that we hate to deal with.
So for this purpose now, sorry, go ahead.
I was just saying, I'll definitely see what additional information I can find out. I know that's kind of the last updates you had, Judge, that we talked about. That's the last updates that I was aware of, but I'll definitely follow up.
All right. And Ms. Kim, if you want, reach out to it. I know there's an email on their website.
Teletrix.
TALITRIX. I think it's .com or I think it's .com.
Okay, so if it's not paid by the county and he can't afford it, then since he's been in jail for so long, would it be possible just to have him fit it with the ankle monitor for now, so he can get released?
Right, absolutely, ankle monitor, right, absolutely.
Okay, thank you, Judge.
All right, have a good one.
You as well.
Good night, everybody.
Good night, Milton. Thank you. So, Miss Rhonda, what was another one of yours? Is there a bond modification?
I'm expecting position 19 and 20, Mr. Quamario Hosh.
All right, so both of those, they were already addressed in bond in May 9th.
May 9th. Okay.
Yeah, thank you.
Then that will be all for me. May I be excused?
Yes, ma'am. Thank you.
I
stole Miss Camacho's thunder, didn't I?
May I be excused as well?
Absolutely. Thank you both.
Thank
All
you.
right. All right. Let's see. So we got, what about Ryan McDonald? This Miller.
Yes, I'm here.
All right. What about Mr. Miller? Mr. McDonald. Sorry.
Thank you, Judge.
Is your client here?
Yes, he's on the Zoom. Mr. McDonald, turn your camera on.
Mr. McDonald, you need to turn your camera on.
Hello.
All right. All right. This is 21 CP 204681. Sorry. Do you want to wave sounding?
I do, Judge.
All right. Go ahead. What are you wanting to? And it's Ryan McDonald. We're waving sounding. Anything I need to know, Bostic?
No, Judge. No changes.
All right. Go ahead, Miss Miller.
Thank you, Judge. This was a consent bond. Mr. McDonald is seeking now permission to have his driver's license back. He has no history of significance, Judge. He surrendered himself on the warrants in this case. This involved a very tragic car accident wherein he was almost killed, and his girlfriend unfortunately did not survive the accident. The details will still get hashed out. I am at a disadvantage as it relates to the discovery, so I won't delve too deep into that, except to say this case has been pending for upwards of 18 months with no indictment. Mr. McDonald was working from home, which is why we did not give any pushback on the surrender the license at the time we were negotiating the bond. He's been laid off from that job since March and is having some pretty significant obstacles in terms of finding gainful employment without being able to drive. So, Your Honor, we would ask that the only modification we're asking for, Judge, is that he be permitted to drive to work.
Mr. Mal, could you pull up the other consent order?
Yes, I do have the consent order up here, and it says consented to by ADA Majeski and Ms. Miller. Good evening, Ms. Miller. That he had to surrender his license to Attorney Miller within 24 hours and was not permitted to drive. I think I saw ADA Mike Wilson on here. Mr. Wilson, are you handling this?
Yes, I am, if I may, Your Honor.
All right, go ahead.
Thank you, Mr. Milton. So, Your Honor, Mike Wilson for the state in this one.
Yes, sir. Go ahead.
The state will be opposed to any modifications, Your Honor. This case has been written up for indictment, Your Honor, and we expect this case to be indicted within the next 48 hours. As to the modification, if the court is inclined to modify it, Your Honor, we would just say that some of the facts in this case are that Mr. McDonald was drag racing on the interstate, Your Honor. His ACR data from the airbag indicated that Mr. McDonald was going in excess of 110 miles an hour at the time of this collision. There was another vehicle that we believe he was drag racing with was going in excess of 101 miles an hour. And as a result of that, Your Honor, the state will be opposed to any modification. And we would ask also that since this case, we do anticipate that this case will be indicted within the next 48 hours, that Your Honor would stay any decision and allow a Superior Court judge to hear this once it's indicted.
Look at that.
Judge,
right, go ahead.
Judge, I would just say in response to that, again, I don't have the discovery. These are complex cases, and it's very difficult for me to push back on that. But certainly, we will do our due diligence. I will note that Mr. McDonald was not charged initially, and the other driver in the case was the at-fault driver, according to the officer's determination. But again, I don't have the state's evidence, and you know. Assuming that he is presumed innocent of these charges, it sounds like we are getting a jump start on punishment by withholding his ability to drive back and forth to work, which is all he is asking to do. Your Honor, I would ask that the court grant this modification. It is not a substantial modification. He does not have a significant driving history. As I understand, he might have had one ticket back in 2018. But Your Honor, again, if he is presumed innocent, he has abided by every single bond condition for the last 18 months. I think I'm glad that the state is deciding to do something with this case. My conversations with Mr. Majeski were a little bit different than Mr. Wilson, who I have not had the pleasure of speaking to about this case. We will be defending him vigorously, Judge. I would ask that we not conclude his guilt or innocence or facts in the case here, and just decide based on the Ayala factors whether or not this is a reasonable modification to his bond. Her Honor has jurisdiction to decide this issue today.
It looks like, according to the pretrial report, it was in 2021. I don't know if there's anything else, but there was a driving license suspended or revoked in Sandy Springs on September the 27th, 2018. Is there anything else, Bostic?
Judge.
You say no?
And if I may, Your Honor.
Yes, sir.
So the state did consent to a bond in this case, Your Honor, because this case, it was still being investigated. Now, as to the other driver being at fault, Your Honor, the other car, airbag data was not compatible. So there was a reconstruction project that was in place at the time. So I think that may have played a part in why the state consented, Your Honor, because we did not know at the time these speeds that I just announced.
Mr. McDonald, you're in court. That means we don't text. We don't text.
Yes, ma'am. I think he's referring to the other driver.
I'm pretty sure Miss Miller does not want you to say a word.
No.
So
he was texting me, Judge, though. He was the equivalent of whispering lawyer's ear, Your Honor. I apologize for that.
No, that's okay, but you're holding it up and I can see you. It's and I get it. But yeah, Miss Miller doesn't want you to say a word. And don't forget, this is being recorded. So shaking your head and doing all that, Miss Miller wants you to sit there just a stone face. I'm gonna place you back on mute. I don't even want you to respond. Don't make a face, don't nod your head, don't shake your head. All of that, Miss Miller, is just cringing. So please don't do that. All right, finish up what you were saying, Mr. Wilson.
Yes, ma'am. So I don't think initially the state had all of the data at hand to essentially accurately and honestly defend any or object to any bond proposals. But again, Your Honor, the case has been written up, and we anticipate within the next 48 hours that this case will be indicted.
Has there been any contact with the victim's family?
Yes, Your Honor.
And what's their position?
Our victim advocate is logged on here, but I think what she indicated was that the victim's family were not opposed to him being allowed to drive.
Ms. Williams, is that?
I think it's Ms. Rolock.
No, Ms. Rolock. Sorry, I saw Ms. Williams on there too.
Good evening, Judge.
Good evening. Do you have contact with Miss Hall's family?
I have contacted the family. They did not have a position with regards to bond.
Okay. All right. If you this is just pulling up with these. So if we stand by 1 second on this one, can we go ahead and handle Derek Rooks real quick?
Okay.
Derek Rooks. All right, Mr. Rooks. Is Mr. Rooks on here? Mr. Rooks, you turn your camera on.
Sir.
Yeah, turn your camera on, Mr. Rooks. All right, this is 22 CP 209351. He's out on bond for aggravated battery. Derek Rooks. Anything I need to know, Bostic?
No changes.
All right, go ahead, Ms. Miller.
Thank you, Judge. I represent 40 years old.
Well, Mr. Rooks, you got to mute yourself because you're listening to it, I think, on YouTube, and we're getting feedback. So turn YouTube off, Mr. Miller. Mr. Rooks, go ahead, Ms. Miller.
Mr. Rooks is 42 years old, Judge. He has never been arrested, as I understand it, for anything in his life. There may have been an FTA related to a case he missed in traffic court, Your Honor, but he does not have any criminal history to my knowledge. We intend to vigorously defend against this case as well. As I understand it, it involved the surprise visit of a young lady who he was dating at the time to his home. The young lady was intoxicated significantly, and there may have been some kind of scuffle between the two as he was trying to get her to leave. She fell and she injured herself. This is not a case involving a weapon, Your Honor. And I believe based on the Ayala factors, Mr. Rooks, there's really no basis to make him wear an ankle monitor. He is gainfully employed. He works for FedEx. He works 7 days a week. He has a set schedule for his work. He has a significant work history. He's a working man, a working citizen of Fulton County who has been placed, I would say, Your Honor, I think probably a little unfairly on an ankle monitor with no evidence to suggest that he is a flight risk or that he would not abide with any order relating to this case. Judge, we also would note that he has been banned from Fulton County based on this first initial sort of criminal case. Your Honor, we would ask that he not be banned from Fulton County, that he be permitted to find and reestablish himself in Fulton County. He lives in Fulton County, and that the ankle monitor be removed. This case has been pending for over a year with no indictment. We are fine with all the other conditions, no contact whatsoever, but he's on a 24-hour curfew. He has an ankle monitor and he's been banned from Fulton County based on a case that has some significant factual disputes, including the alleged victim's friend who indicates that she wants no parts of being a witness on her behalf and has stated to previous counsel that the alleged victim was extremely intoxicated and extremely unruly while at his home. So that is not to say that we're prepared, that we're trying the case today. We're not, Judge. We are still conducting investigation. We are just talking about the quality of Mr. Rooks's life. He's had no issues since he's been on bond. I don't anticipate any issues while on bond. So we would just ask that he be permitted to take his ankle monitor off, to move about his life in terms of getting to work and going to wherever he wants to go, as long as he remains a law-abiding citizen while on bond and respects the conditions of this court, Your Honor.
So he did not live in Fulton County.
He did, but he was forced to move out of Fulton County as a result of the initial bond conditions. So he is now not living in Fulton County. He's staying with family, but it would be his preference to reside in Fulton County. It's his home county. It's where he is a citizen. It's where he's lived for years.
Because I had an Ellenwood address for where he lived.
He was living at the time in Fulton County, which was where the incident occurred, Judge.
Okay, so that's why he was told, and he said he was going to live someplace else. All right. And when did he get this ankle monitor on?
As I understand it was September of 22.
All right. Mr. Malkin, what's your position? I know what Judge McBurney has said once I spoke with him.
Okay. So it appears from the warrant this was not an accident, and the victim had some serious injuries resulting in the aggravated battery charge. And I think the ankle monitor is necessary also for the protection of the victim. If some harm should come to the victim, hopefully it wouldn't, but if the defendant violates his bond conditions, then that is also for the safety of the victim. So the state is opposed to the ankle monitor being removed at this time.
So, Ms. Miller, we can make it, obviously, if he is, schedule or job at FedEx leads him to come to Fulton County, that's fine.
I guess, Your Honor, I guess my question about the conditions as they relate to Mr. Rooks is what factually are they based on? If we're looking at the
the safety and intimidation of the safety of the victim.
But he has not threatened the victim in any way. He's been on bond. This arrest occurred in May. He's had no contact with the alleged victim. Even the warrant itself describes some disputed issues as it relates to the facts of the case. He was at his.
And I spoke with Judge McBurney. We both agreed that 1 year with an ankle monitor. So I'll be glad to take it off in September. Something comes up before then, be glad to. If he needs to move back to somewhere else in Fulton County, I'll be glad to amend that. Is that what you want to do?
If that is the court, that's the court.
Obviously not the incident location if the alleged victim lives there, but.
She does not live there, Judge. I'm not sure if she lives in Fulton County, but he's banned from Fulton County and he's wearing an ankle monitor in a case that involves no weapon, where he has no history and he's had 0 violations.
Hold on, sorry. It's raining, so of course my Odyssey's just like spinning, acting really slow, so I was trying to pull it up. All right, so I'll tell you what, if you see. There it is. I'll remove the stay out of Fulton County so we can come back to Fulton County. And then the ankle monitor, the conditions and the court medical and work applies to whichever, whenever he's working. Obviously, if he has an overnight shift, then he can do it on an overnight shift. It looks like Miss Warren is on the line if she wants to say something. Miss Warren? Miss Jackson, sorry. Miss Jackson. Miss Warren, is it Warren or Jackson? I've got Jackson. Miss Williams or one of the advocates, is that, it says Tyria Jackson. Is that the same thing as Tyria Warren? Anyone? Are you Miss Warren? Can you take yourself off mute?
I'm Tiara Jackson.
Okay. Is it also Miss Warren?
No, just Miss Jackson is number 5.
All right. Thank you. All right, sorry. Okay, so we'll remove the stay out of Fulton County. He can come back to Fulton County. Still stay away from that address and the victim. Okay, Ms. Miller.
Yes, Your Honor. Is he still on curfew for 24 hours?
What is court, medical, attorney visits, employment? So there you go. What else do you want? He can do the basic life necessities. Obviously, he's going to be moving, so he can do these basic life necessities. But come back around end of July.
Yes, Your Honor.
End of July, there's no, he's on the straight and narrow and doesn't mess up, then I'll be glad to modify it then.
Yes, Judge.
That sound good?
Yes, Your Honor.
It could sound better, but right. All right. Yeah, so you can change this. He can come back to Fulton County, basic life necessities, because he'll live by himself, right?
Yes, Your Honor.
You can put basic life necessities as far as like gross, things like that. And of course, when he's moving, he can obviously, just as long as he lets you know in the ankle monitoring company, okay?
Yes, Judge.
All right. So now we're back. We'll go back to Mr.
Judge,
McDonald.
Miss Miller will be submitting the order modified.
Okay. All right. So we'll go back to Miss McDonald, I think. Ms. Rolak.
Judge, I've been in contact with Ms. Ryder and she is okay with the modification.
Mr. Wilson?
Well, we'll leave it in the court's hand, Your Honor.
All right, so here's what we're going to do, because I'm going to make sure, and you're going to hate this, Ms. Miller. I'm going to put an ankle monitor on him at least until for at least 3 months to make sure that the only place he is driving is to work and back. Period.
Yes, Your Honor.
Period. Someone lost their life. Allegedly, not allegedly lost their life, but allegedly because of drag racing and stuff on the interstate. And it's to work and back. Period. Ankle monitor can be paid for by the county, but it'll be a 24-hour curfew. Court, lawyer, medical, and employment. He has to supply the name of his employer, proof of employment, schedule, and the exact location he'll be working. Mr. McDonald, that is to work and back. You take lunch with you. I don't want you to leave work for lunch. Yes, ma'am.
Just a quick clarification. He's not on 24-hour curfew now. But
well, he will be now. I mean, basic life skills. He can't drive. I just want to make sure that he's not driving anywhere back and forth to work, period.
No, I understand, Judge. I guess I'm just saying, if he wants to Uber somewhere like he has been doing, can he still Uber as opposed to, I understand driving only to work and from, but being on house arrest, basically.
All right, so we'll make his curfew will be from 10 p.m. at night till 6 a.m. So we're from 10 p.m. to 6 a.m. So
we're raising the conditions of his bond?
Does he need to stay out past 10 p.m.?
It's just it is that he has been out for 18 months, able to matriculate however he wants.
Mr. Wilson doesn't want him to drive at all. So what do you want to do, Mr. Wilson?
Well, if our original proposal was, Your Honor, that you stay any decision and let the Superior Court hear it, we can go back to that.
He does that to me all the time, Ms. Miller.
Or it can just be that he can only drive to and from work.
But you're going to have an ankle monitor, sir. Only drive to and from work. You're going to have an ankle monitor because they're going to monitor where you drive to, just so you know. They're keeping an eye on you, Mr. McDonald. That is the only time you are to drive. Take a lunch with you. Don't stop and get lunch. Don't stop and get groceries. You can Uber to the grocery store, to and from work. And you abide by every single traffic law that there is out there and ones that may be created after the day. Best of luck to you, sir. I'll look for that, Miss Miller. If you could just shoot it straight to me.
I will, Judge.
Okay. All right.
Have you, Your Honor?
Yes, sir.
Thank you, Your Honor.
Right. I got Demetrius Ballard. Thank you, Miss Miller.
Thank you, Judge.
Good morning, Judge. Tom Tierney here for Ms. Ballard. Ms. Ballard's here.
All right. Let's see. Mr. Ballard, you got to turn on your camera, Mr. Ballard. I don't see. Oh, there he is. All right. This is number 4, Bostic 22 CP 212270, Demetrius Ballard. Anything I need to know, Bostic?
Don't see any changes.
All right, Mr.
Judge,
where's Mr. Ballard? Hold on. Mr. Ballard, you got to turn your camera on.
You turn on? Oh, start video.
Go ahead, Mr. Tierney. Just
Mr. Ballard is 40 years old. He has a company called Double A Grading Company. In June of 2022, he had some day workers that he fired that jumped him. He left with one of his cars, trucks, came back to get another truck, got the truck. 3 months later, he's in Clayton County, gets arrested. Apparently there's an allegation that he shot at them or something like that. Apparently the state has a shell, but no weapon. He was in jail for 72 days. He has been out on a bond, $55,000 bond that he made. He has no criminal history of violence. He has a felony for drug possession, I understand, when he was a young man. He has a family. He's on an ankle monitor. The state's going to proceed. They need to do something. I understand from sitting here that there's a big backlog, but his freedom is being curtailed. He needs his freedom, and we're just asking the court to consider taking him off the ankle monitor.
When did you get it put on?
I believe when he got the bond, which I think was in November 21, 2022.
Oh, November 2022. Mr. Malkin?
Your Honor, state believes the ankle monitor is still appropriate at this time and maybe revisit it the request in a few months, but it hasn't been a year. So I would say at least 3 months. Looks like it's been about 6 months or so.
All right.
7 months.
Mr. Tierney.
I mean, we'd ask to be, I mean, I don't know what 3 months is going to make a difference, but I understand from hearing your prior case that the court may do that.
Yeah, I mean, we kind of came up with that. So if you want to come back on in 3 months, let me see. Let me pull up his order. Did I give him, what conditions did I give? Did I allow for work too?
I'm sorry?
Did I allow for employment with the ankle monitor?
Yeah. He's working.
Okay. Yeah, so if you want to come back in about 3 months, well, what's that? 1st of August, then we'll look at if there's no
So just refile the motion and get back on a calendar the way I did this one.
Yeah, that's fine. Yeah.
All right. Thank you, Judge.
Thanks. Have a good one. All right. So now we got Miss Tiara Jackson. Okay. All right. It's position 5, 21 CP 202 725. Tiara Jackson, 2 counts of aggravated assault with a deadly weapon. Anything I need to know, Bostic?
Don't see any changes.
All right. Go ahead, Mr. Matthews.
Yes. Good afternoon, Judge. I believe my client's been on this ankle monitor for 18 months. I'm not sure if she's been indicted. I don't believe she has.
No, sir.
The facts of the case are the gentleman, he punched her in the face several times and he slung her. So she got a knife in her purse and stabbed him. She had been pregnant at the time and lost the baby. She was about only 6 weeks pregnant. Her family situation's precarious because she's living with her brother. She needs the freedom to be able to get her own job and get her own place. And we feel like with the 18 months on the ankle monitor, it's interfering with her ability to have her livelihood so she can be independent. And she's already got kicked out of her mom's, and the brother, he's saying, he's got his own baby, his own family. He's saying she's going to have to leave. And so we're asking the ankle monitor be removed.
Mr. Malcolm, it's been 18 months. You good?
Has been 18 months. Yes, Your Honor.
All right, Ms. Jackson. So I guess you just need to make arrangements with the ankle monitor company and get it cut off. Mr. Matthews, you'll just submit an order. I'll sign it.
I can get one over to Trevori Robinson if that's okay.
Yes, sir. She'll send it to me.
Okay. Thank you, Judge.
All right. As soon as I get it, Ms. Jackson, I'll sign it and you just make the arrangements. Okay. Thank you, Ms. Jackson. Best of luck to you. Have a good evening. All right. Now I got, let's see. Listy Johnson.
Judge, that one, the state declined to prosecute, so they're not going.
Okay. All right. Let's see. Last but not least, Frederick Wu, Mr. Wu. All right. This is 22 CP 206 649. Computer invasion of privacy. Anything I need to know, Bostic?
What is his request? First, is he requesting to be off pretrial or what? Because it's been closed on pretrial.
I mean, we'd love to be off pretrial, Your Honor. At this point, we're just asking for the ability to personal travel. But I mean, coming off pretrial may be appropriate given it's been 15 months. It's not that serious a charge.
Yeah. So
that's the thing. It was closed on pretrial in November, actually. I'm sorry, Miss Grandy.
So we're taking. So he's off. Hold on. So we'll take him off pretrial, right? Because he's off there. Right, Bostic?
Yeah, that case was closed in pretrial November 30th of 2022 because of the standing order.
All right. So where's he want to travel, Mr. Timmons?
Just personally, Judge, he has no plans right now, but I mean, I'm paid by the hour. And so it's a lot easier for him if he could just travel and not force me to come back every single time. In a nutshell, Your Honor, he resides in Georgia. The victim resides in Georgia. So to the extent he's traveling personally, I guess the victim would be even safer if he was out of town. As far as we're concerned, it's a minor charge. We plan on fighting it. Judge, I have one criminal case. This is it. And the only cases that I'll take on the criminal side is if my client is absolutely innocent, which is the case in this particular case. We have an affidavit from an expert that indicates that the detective lied in his warrant. We actually brought that to the Public Integrity Unit in Fulton County. The detective stated that my client used a SIM card for a different phone number to invade the privacy of the victim. our expert, who's a computer expert, I believe is extensive degrees, extensive experience, will tell you that you cannot look at somebody's personal information by having a cell phone with the same number. And we kind of all know that because there's no new phone numbers under the sun. I just got a new SIM card for a cell phone. It was somebody else's phone number. I get some of their calls, but I can't invade their personal information by having that cell phone. So the crime at the alleged computer invasion of privacy by Mr. Wu getting a hold of a SIM card and using that to invade this person's privacy is a legal and practical and factual impossibility. Mr. Wu's corporation has retained me. They've also retained former U.S. attorney of the Northern District, former U.S. attorney of the Middle District, and the first general counsel of the Department of Homeland Security to represent as co-counsel from the Womble Bond firm as well. We plan on fighting these charges if we can't get the DA's office's attention. We'll listen, I suspect, once we get a chance to actually talk to somebody. And I'd love to talk to Mr. Malkin about it and happy to send him the affidavit from our expert, but this is one that needs to go away. And so in the meantime, Your Honor, we're requesting simply at this point that he can travel without us having to come to the court and say, okay, he's planning on going on a vacation to Florida on this particular time. When it doesn't make any sense. Right now, he's able to travel for work. If he was a flight risk, he'd just say he was traveling for work and, disappear at that particular time. And he's been traveling for work all the way along. So this is sort of a nuisance requirement on bond rather than anything that's serving any particular purpose. So given that, Your Honor, we're requesting that he be allowed to travel for personal without having to come to the court every single time that he wants to take a trip.
So, Mr. Malkin, some of these I've definitely made it, all they had to do was let you know when they were going somewhere, as opposed to coming back and getting an order. What do you?
Right. Good evening, Mr. Timmons.
Hello, Mr. Malkin. Wonderful to see you.
Wonderful to see you as well. And is this a situation where he could turn in his passport?
No, he's not. He hasn't turned in his passport. He's not forbidden from international travel. It's one of those things where we have to come back to court to have him travel. If he was a flight risk, he would have disappeared 15 months ago.
Does he need to travel internationally, or could he turn in his passport and then be able to travel?
My experience with turning in passports, having been in a district attorney's office for 17 years, is that those passports never seem to make it back to the people who have them. And it's a giant
Timmons,
pain.
I know that you're reliable, that you would lock that in your safe at your office.
I'm sure we did, Judge, but you know how those evidence rooms get over time where people go to find something.
You keep it at your office, like you.
Oh, I'm happy to keep. Sure, I can keep it at my office. That's fine. That's not a problem.
I think that's what he's asking, right, Mr. Malkin? That his passport will be surrendered to Mr. Timmons, and that way.
Oh yeah, cool.
Yeah, would that work? Okay,
sure, that's fine. And then I'll just notify your office if he plans on traveling internationally.
I think then he would want permission.
Sure, if he wants internationally, but I think right now he's just looking to go to Florida or California or places like that. I mean, if we could travel domestically and then come for permission on an international trip, I think that would work.
I don't think I have an issue with that, Chris. And yeah, if he wants to travel internationally, then we'll probably have to revisit that with the judge. But for domestic, why don't you take possession of his passport, lock it in your safe, and don't give it back to him without court permission?
Sure, that works for me.
Okay.
And I'm sure it will work for Mr. Wu. That gets us a little farther down the line. But yeah, I mean, I am serious about getting somebody to look at this case at some point, because it really is. It is a legal impossibility for him to do that. The detective signed a warrant, swore under the penalty of perjury that this happened, and said that he knew computers well enough to say that this could happen, and that's a lie. And I've prosecuted when I was the head of the public integrity unit in DeKalb County. I prosecuted for detectives for doing the exact same thing, which is why I went to the Fulton DA's office's unit about it. It's just a shame that with COVID that this case has hung around for 15 months.
All right, you can just send me that bond modification. Stick around, Mr. Timmons, for a second. We'll talk to you about something else. Oh, not
sure. Happy to. I'll stop billing you, Mr. Wu. We're good.
Thank you, Mr. Wu. I think that's it, right?
That's it.
That's it, Judge.
All right.
Judge, I'm sorry, I might have missed what happened to position number 17. Was that the one you guys were saying was going to get reset?
Yes.
Yes.
Okay. Okay, thank you. Did we have a reset date just like put on my calendar or no?